I have a little, well, I didn't mean to do that. I have a little party going on in the back for the ladies of the Senate, so we're going to see how we can. I thought I turned it off. Okay. So,
Perhaps committee staff can give very brief summaries.
so this is Thursday, February 20th. This is the Finance Committee, and we are starting our voting session with Nathan and Senate Bill 52.
Yes, ma'am. Senate Bill 52, for which you have a reprint, makes various changes to the State Board of Chiropractic Examiners and the law governing chiropractic licensure, including altering the board member appointment methods, that's found on page 3, expanding disciplinary grounds on page 11, and granting the board authority to conduct certain examinations of licensees and inspections. Those are on page 8. Revising licensure qualifications, including changes to education requirements and board-administered examinations, and then finally replacing the extern license with a preceptorship and authorizing the board to issue temporary licenses. So the amendments increase from 15 to 20 the number of chiropractors required to nominate an individual to the board. And so that's the change I referenced on page 3. And it makes other technical and clarifying changes at the request of the Chiropractic Association. There is no fiscal impact, and with the amendments, no opposition.
Can I have a motion for the bill as amended? Senator Lamb, can I have a second, please?
Second.
Senator Kramer, we have a motion and a second. All in favor of the Senate Bill 52 as amended? It's a unanimous vote. Thank you.
Next is Senate Bill 67, which, as amended and shown in the reprint, authorizes each health occupations board to establish a process to include a notation of an individual's veteran status on a license, certificate, registration, or public profile. And so if a board establishes such a process, the application for the credential must allow the applicant to consent to two things. One, having the notation on their credential, and then also consent to being contacted by an appropriate executive branch agency about eligibility for certain state or federal veterans benefits. And so then on request of an executive branch agency and in accordance with the Public Information Act, the board is required to share appropriate information about the applicant with the executive branch agency. So the amendment adds references to public profile as described, and then strikes provisions related to the board assisting in the determinations of eligibility for benefits. The amendments address the concerns raised by the Board of Physicians. There is no fiscal impact.
Do I have any questions? Any motion?
Okay.
Senator Gall as amended. Senator Kramer, second. All in favor of Senate Bill 67? Unanimous vote. Thank you.
Next is Senate Bill 72, which, as amended and shown in the reprint, prohibits a health occupations board from requiring an applicant to provide additional evidence of English proficiency if the individual holds a valid, unrestricted license, certification, or registration from another state that requires such evidence. Each health occupations board that requires evidence of English proficiency must maintain on its website a statement that an applicant may not be required to provide additional evidence of English proficiency if the individual holds a valid credential in another state. The bill also alters English proficiency requirements for the Board of Nursing and the Board of Pharmacy to align with the bill's requirements. So the amendment strikes.
Move favorable.
Second.
There we go.
Senator Kramer moved favorable. Senator Lamb moved second. All in favor of Senate Bill 72? Unanimous vote. Senate Bill 174, Interstate Social Work Licensure Compact.
This bill enters Maryland into the Interstate Social Work Licensure Compact. So there's a reprint where only the affected pages of the, or where only the pages affected by an amendment are reproduced. These make technical corrections for consistency with the Interstate Compact.
Motion for the bill as amended?
I have a question.
Go ahead.
I had a request about holding for a week because we're trying to adjudicate the other issue. Is it
Other issue.
With the test.
It has nothing to do with that bill.
Okay, good. I'm just trying to, I had somebody talk to me about it. I'm just
No.
trying to be sure I
So-
understand the framework.
The
Yeah.
compact would require that you have taken the test in order to honor the compact as a Maryland
Right.
social worker. But we haven't made any decisions on whether Marylanders have to take the test. So if you're a Marylander that didn't take the test, you can't go to other states under the compact. You can't, no matter what we do with that bill. The bill says you have to take a national exam. The compact, this bill we're looking at, says you have to have
Okay.
passed a national exam.
So, okay, all right.
Okay?
Thank you very
All right.
much.
Can I have a motion for the amendment, Senator Mounts? Can I have a second, Senator Ellis? All in favor of the Interstate Social Work, Senate Bill 174? Unanimous vote, thank you.
Senate Bill 495, as shown in the reprint, authorizes the authorized uses of the opioid restitution fund to include providing funds for operating expenses and personnel cost for investigations, enforcement actions, and other activities for the opioids enforcement unit within the Office of the Attorney General. The amendment requires OAG to submit an annual report on the activities of the enforcement unit and then terminates the bill after 4 years.
Second.
Senator Ellis moved favorable, Senator Kramer second. Senator Mounts has a question.
Questions about, this was taking money from the opioid restitution fund and putting it in to the Attorney General's office, right? And how much, what was the amount that we were talking about, the bill's proposing?
I want to be clear that the Office of the Attorney General's position is that it's not taking money, it's adding an additional authorized use, and that the settlement funds include some portion that was already designated for administrative expenses, and that those funds are therefore within the confines of the settlement or the judgment, depending on the case.
So I was
are
very
limited for that
interested in this
purpose.
debate and this discussion because we're going to use the monies, right, to empower the Attorney General's office to go to the table and do this negotiation. But there's no hook that the monies are returned. So it's like an investment on return. So if the money were moved to the Attorney General's office, there's nothing that says that the Attorney General's office, after they recover more funds, that those monies go back. But I guess that may be a little circuitous, though, I guess because the argument is that they're going to bring more money back, and so therefore there isn't a reason for a return. Is that sort of the argument and counter, or the suggestion and counter suggestion?
I believe the position of the Office of the Attorney General is that if they secure additional judgments or settlements related to violations of state law related to opioids,
They would go
then
back.
that money would go into the fund, and so that it would, to use your phrase, be a return on investment. And I didn't quite finish answering your first question, which was that the Office of the Attorney General is specific. They cite the number $1.5 million in fiscal year 2026 under the bill.
And that's the same fund that provides grants to all of our community organizations that apply.
That is correct.
Okay, thank you.
Okay, we got a motion and a second. Question. And a question.
495, right?
Yeah, just a quick question.
Sure.
Madam Chair, thank you. I just saw that MACO was opposed to this. Just wondering if the amendment that was offered addresses their concern, or are they still in opposition to this?
I don't have, let me see here. So with the text of the amendment that you see produced in the reprint before you that's offered by the bill's sponsor, the Office of the Attorney General said that the Office of the Attorney General and advocates representing the National Council on Alcoholism and Drug Dependence of Maryland came to the agreement on the attached language. So they don't, in that email, reference MACO.
Okay. All right. All right, thank you.
What would you like to do, Senator? You want to hold it?
Yeah, I think I'd like to hold it
Okay.
just until.
Senator Hershey's holding Senate Bill 495. Okay, thank you. Hold. Senate Bill 594.
Next is Senate Bill 594, also sponsored by Senator Ellis and related to the opioid restitution fund. So as amended and shown in the reprint before you, Senate Bill 594 repeals the explicit delineation of certain authorized uses of the opioid restitution fund and instead specifies that the fund may only be used to provide funds for the purposes specified in settlement agreements and judgments relating to claims by the state against the opioid industry for violations of state law. The bill specifies that these purposes may include addressing racial disparities in access to prevention, harm reduction, treatment, and recovery support services. And then the bill also alters training on responding to an opioid overdose to include emphasizing the restoration of breathing, avoiding withdrawal, and compassionate post-overdose support and care. So the amendment that you see before you corrects what was described as a drafting error, striking the additional references to specified programs, services, supports, and resources. There is no fiscal impact.
Motion? Okay.
So the fund may be used only to provide funds for things specified in settlements, including, the language on page 4 of the reprint about disparities, that would have to be specified in a settlement, correct? That's under the same part, right?
Right, so the bill strikes the enumerated items under F1, and then
see
the
that.
provision that you're talking about is added as F3. So,
So for example,
But
it's
it
a
would-
lawsuit that an opioid manufacturer targeted a certain community, so therefore there needs to be restitution, including ways to address that racial disparity of what was done in that community, correct?
that's my understanding.
Generally
yes.
speaking. Okay, no, that's fine. Okay, thank you. I'm good.
You're going to move favorable? Do I have a second for favorable as amended? Senator Lamb. All in favor of Senate Bill 594 as amended? Unanimous vote. Thank you.
Next is Senate Bill 674, for which you have a reprint. This establishes the Maryland Collaborative to Advance Implementation of Coverage of Over-the-Counter Birth Control within the Maryland Commission for Women. The purpose of the collaborative is to study and make recommendations to advance access to over-the-counter birth control. And the commission must provide staff for the collaborative, and the collaborative must submit an interim and final report at dates specified in the bill. The amendment on page 4 authorizes the collaborative to consult with health professional associations in addition to other organizations as part of the study. There is no fiscal impact.
Move favorable.
Thank you, Senator Hall, and Senator Lamb seconded. All in favor of
Over-the-counter birth control, do we consider abortion pills to be over-the-counter birth control? Okay. That's the question I had. So we're working to make sure birth control is available without a prescription over-the-counter? Oh, I agree with that. That's good. I just wanted to be sure we weren't including like RU 486 or something, so.
We have a motion by Senator Fowle and a second by Senator Lamb. All in favor of Senate Bill 674? Unanimous.
Ready to move on? Great. So the next bill is Senate Bill 684, and as shown in the reprint, requires the Department of Health in collaboration with the Commission on Health Equity to develop a clear and easy to understand graphic data dashboard that includes age-adjusted health disparity data disaggregated by race, ethnicity, and gender. The dashboard must include specified information as well as any other health indicators determined to be relevant by the department.
Move favorable.
There's an amendment that alters the frequency at which the department must update the dashboard from
As amended.
monthly to quarterly.
In a second.
Who's the second?
Senator Giles.
Senate Bill 665. Oh, it's Amber's turn.
Indeed. All right. You ready, Madam Chair?
Yep.
Moving to Senate Bill 49, establishes a regulatory framework to govern automatic renewals between a consumer and a seller in which a paid subscription or purchasing agreement is automatically renewed at the end of a definite term of more than 1 month for a subsequent term, and requires that the seller allow a consumer to terminate an automatic renewal in a cost-effective, timely, and easy-to-use manner. A violation of the bill is an unfair, abusive, or deceptive trade practice under the Consumer Protection Act, and violators are generally subject to the civil and criminal penalty provisions, but not subject to any private action for damages under the Consumer Protection Act. You should have a reprint before you with several amendments offered by the bill sponsor and one by Senator Mounts. Starting on page 3, there are some minor clarifying adjustments. Moving to page 4, there's an elimination of the requirement for the telephone to be toll-free. And then down to, on page 3, line 18, this is Senator Mounts' amendment that limits application of the bill to a free gift or trial offer that lasts more than 31 days. That continues again at the top of page 5. It's two pieces where we're limited to offers that are more than 31 days. The remaining amendments are offered by the bill sponsor, outlines the conditions that must be met in order to automatically charge a consumer's credit card, adds entities that are licensed under Title 18 of the Business, Occupations, and Professions article to those deemed to be in compliance if they're currently in compliance with contract renewal procedures under state law. And the next excludes certain regulated services from the act. The final amendment delays the effective date of the act until June 1, 2026. There's no physical impact.
Senator Bond.
Thank you, Madam Chair. I would just respectfully to my protocol committee co-chair, I'm opposed to his requested amendment. While I appreciate the concerns that were raised, we discussed this, my cross-file and I know that it's being requested on behalf of Adobe, I believe. And we think that most of the time the trial offers are like 7 days or something, and that's how they end up sucking you in. I think if it goes beyond something like with the 31 days, I just think that it renders in a lot of ways it being ineffective, because most trials that suck you into automatic renewals.
Senator, why don't we hold this bill and see if you can work this out and review the amendments with Senator Mounts, okay?
I appreciate it. Thank you, Madam Chair.
Thank you. So we're holding Senate Bill 49. All right, Senate Bill 302.
Senate Bill 302 removes the award and investment limits under the Maryland Small Business Innovation, Research, and Technology Transfer Incentive Program within TEDCO. A business is still limited to 1 award or investment per fiscal year and 3 awards or investments in total. There are no amendments and there's no fiscal impact. There was no opposition at the committee hearing.
Senator Lamb moved favorable, Senator Gall seconded. All in favor of Senate Bill 302? Unanimous vote, thank you. Okay, Senate Bill 439.
Senate Bill 439 alters the definition of a high-impact economic development activity, or HIDA, to exclude cost savings related to the reduction in the number of university employees. Additionally, the University System of Maryland Board of Regents must include additional information in its annual report on HIDAs. The bill also repeals the authorization for officials or employees of public higher education institutions to serve as directors, officials, or employees of entities supporting HIDAs, and makes the entities subject to the state's procurement law. You do have a reprint. It's primarily a technical amendment. There is parallel language that relates to Morgan State University under their portion of the code. So it adds the exact same language that was in the bill for USM as introduced and applies it to the Morgan State University. There's no fiscal impact and there was no opposition at the committee hearing.
And apparently GSM supports the bill as amended. Senator Lamb? Favorable? Senator? Oh, Senator Ellis.
Yeah, so thank you, Madam Chair. So there was an issue at the hearing with these hiders being subject to audit by our legislative orders. Did any amendments address that, make it clear that these companies are subject to audit? And I apologize, I should have looked at that before, but events kind of overtook me.
Sure, so this does not affect the audit. That is going to continue to be an ongoing issue depending on how the HIDA is structured and whether they are private such that their books can be segregated, despite state law that requires anything that has state dollars flowing through it should be audited.
Yeah.
I do believe in this specific instance, UMGC's HIDA has agreed to open its books, but the audit has already concluded, so we're kind of in a holding pattern for what the OLA is going to do.
Yeah. I would love to put an amendment in to require IDAs, because they get state money, subject to audits from our legislative orders. Should I hold it in, or could we just put that in?
We'll hold it for the amendment.
Okay, all right, great, thank you.
Because we have to be sure that they can require it.
I
We're
think
not sure that you can require an amendment, that's why we're going to hold it until you figure that out,
Okay,
okay?
sure, thank you.
To allow OLA to come in.
They agreed, and they came and met with me and told me they agree, but I think there's an issue with whether or not we can require it. That's what I'm not sure about.
because of the entities are structured as private entities, they're not public entities, so they're not necessarily subject to the audit by the state.
Senator Reedy?
Well, here's a question. I mean, I like this bill. Well, I guess you may much rather hold it. I know we're trying to pilot for next, so I was saying we move it and then do a floor amendment, but you probably prefer not to.
No, let's hold it.
Just to be sure.
and,
I agree with him. If we could audit, it'd be great, but if we can't, yeah, okay.
Let's try to get the answer. Thank you. Okay, Senate Bill 522.
Senate Bill 522, as amended, requires that a person registered as a home builder in the state provide, at the time of closing for the initial sale of a new home, specified information about the warranties for any appliance in the home as registered by the home builder. Under the bill, appliance includes the heating, ventilation, and air conditioning systems. You have a reprint. Amendment 1 is technical. Amendment 2 requires the home builder to provide the warranty information at closing rather than in the contract for initial sale of the new home. This was requested by the Office of the Attorney General because the warranty information is not going to be had at the time of the initial contract by the home builder, but they will have it at closing once the home is actually built. There's no fiscal impact.
You move favorable. Senator Lamb, move favorable. Can I have a second? Senator Jackson, you need to do a second. It's your turn. All in favor of Senate Bill 522? It's a unanimous vote. Thank you. Okay.
Senate Bill 523 may entitle all state employees, including temporary and part-time employees, to up to 4 hours of paid cancer screening leave in any 12-month period for cancer screenings after obtaining approval from their appointing authority. The Secretary of the Department of Budget and Management must adopt regulations governing cancer screening leave. There are no amendments, and there is no opposition at the committee hearing.
Senator Reedy?
I don't want to be this, but state employees have a lot of paid leave time. And I know it's cancer, but are we sure, what is the fiscal impact? Is the fiscal note accurate on, I mean, I guess they're going to say it's built into your leave.
Right. So what the fiscal impact was, expenditures for all funds across all state employment agencies increased probably minimally, and it's for basically usually related to overtime costs for coverage to the
Right.
extent they don't have enough coverage for that person using 4 hours of leave.
Here's
But it's a small
My
increase.
challenge on this, I hate to vote against leave for cancer, people getting screened for cancer, but we're in a $3 billion budget deficit, and we give a very generous package to our state employees for as far as leave compared to the private sector. And so there's no way to amend the bill. So, I mean, if you told me it's like they can never be turned down to use what they already have, that's fine, but you already can't be anyway for sick leave or annual leave or, all right, well.
Look into your heart.
All right, so, did I have a motion? I thought I had a motion. No.
Favorable, we have.
Senator Kramer moved favorable. Is there a second?
Second.
Senator Jackson? All right,
Moving them on.
we're gonna do a roll call. Tammy's gonna do a roll call.
Senate Bill 523, favorable. Vice Chair Hayes.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
No.
No. Senator Ellis.
That lump of
Yes.
coal.
Senator Mounts. No. Senator Jackson.
Yes.
Yes. Senator Washington.
Yes.
Yes. Senator Guile. Yes. Senator Lamb.
Yes.
Yes. Senator Hershey. No. Madam Chair.
Yes,
Yes. 8-3, the bill passes.
imagine 8-3. Thank you. Next, we're gonna do 578.
Senate Bill 578 authorizes the Maryland Home Improvement Commission to award a claimant attorney's fees from the Home Improvement Guarantee Fund up to the amount awarded for the actual loss and provided that the total award does not exceed $30,000. The bill also repeals a requirement that a final court judgment or final award in arbitration expressly find on the merits that a claimant is entitled to an award from the fund in order to recover compensation. Amendment 1 was described, it just clarifies that the total award, including the attorney's fees, cannot exceed the $30,000, and adds other clarifying language. And that's all.
Okay. It's just really the ease of collecting the money that it had been awarded, right?
Correct, Madam Chair.
Okay, so Senate Bill 578 as amended? Okay.
Yeah, Amber, the Maryland Building Industry Association was opposed to it. Did the amendment do anything to relieve their opposition?
Not of which I'm aware, but Senator Lamb is the sponsor of the bill and the amendment. He may be able to speak to that.
Take that as a no.
Are we talking about 578?
Yes.
Yeah, so the MBIA's letter was just wholly inaccurate. Like, we tried to contact them to straighten the record on a lot of the stuff, so they had a letter of opposition there. But they claimed things that just were not accurate. It said that they would decrease the cap, that the bill would decrease the cap from 50,000 to 30,000. This bill doesn't change that cap. The cap is still the current 30,000. We're also not increasing the mandatory statutory balance. I'm not sure why they're referencing that. We did contact MBIA and asked them if they could clarify what their concerns were, because the factual basis of the letter is all wrong, but we never heard back. So that's what.
If I can recall from the hearing, these are claims where they had been arbitrated or ruled on, and yet people were still having a problem getting their award.
Yeah, there are two main provisions in the bill. One has to do with what you were just referencing, which is there's a word expressly in the statute. And I think based on arbitration and how those rulings come out, you know, some folks were interpreting that to not fall under expressly, and so some people couldn't get paid out. So that's why we're removing the word expressly. And then the other piece is the attorney's fees, because oftentimes they may have to appeal further up the line, and then the homeowner would be stuck with the attorney's fees. So this, you know, that is post-arbitration. I think there was a question about that. That was post-arbitration.
I'll take your word for it, and if we find out different when it moves, then we'll do that.
Before it
But-
gets-
Yeah, we'll do that. But, all right, thank you very much.
So Senate Bill 578 as amended, I need a motion. Favorable and second, Senator Ellis. Okay, are we all in favor of Senate Bill 578? No opposition? Okay, Senate Bill 578 is favorable.
Senate Bill 665 generally modernizes the Maryland Uniform Disposition of Abandoned Property Act, which governs the distribution of abandoned property in the state. Among other provisions, the bill explicitly applies the requirements of the act to additional forms of property, including virtual currency, establishes various new requirements and procedures related to abandoned property claims to align with national best practices, authorizes the comptroller to waive the filing requirement and instead directly distribute funds of less than $5,000 to Maryland residents under certain circumstances, and authorizes the comptroller to retain additional proceeds from the sale of abandoned property used for specified purposes. There are no amendments and there is no opposition at the committee hearing.
All in favorable of, you move favorable, Senator Hayes, second. Do you have a question, Senator Reed? You're seconding.
Enthusiastically support.
Okay, we have a motion and a second. Are we in favor? Okay, we're voting. Senate Bill 665, all in favor of 665? Senator Gott, unanimous vote, thank you. And then we have, nope, not quite.
The last one on your list, Senate Bill 867. You're voting to re-refer this bill, which is nearly identical to another bill that Triple E is hearing or has already heard.
Motion, Antonio Hayes, second. Yes.
What's a re-refer? I'm not sure of what that means.
Past the date where the president can just say it's being referred to a different committee, so we have to vote to re-refer it.
So it's here now in this
Yes.
committee? And we're sending it somewhere else?
We're sending it back to EEE where the other similar bill was heard.
Releasing it from our
Okay.
I have-
budgets and handing it back to our.
I have spoken with the committee as well as the president's office, who are both in agreement with the
Okay,
referral.
yeah. I was just curious about the
Okay. Well,
terminology,
that's the first time
how
I've
it
seen it
moves,
too,
yeah.
yeah.
Yeah, thank you.
So all in favor of the re-referral? Okay, great. One less bill for us to worry about. Okay, now we have 3 bills by David and 2 withdrawals. So David, you're up.
Okay, the first bill on the last page of your voting list is Senate Bill 26. It does basically 3 things. I'll go in order of importance here. One, it adds additional provisions throughout the laws governing occupational safety and health in Maryland regarding workplace safety for public employees. So all these provisions added do not apply to the private sector. They only apply to public employees, and it's related to workplace violence. The second thing the bill does is it creates a public employee safety and health unit within the Commissioner of Labor and Industry to oversee and administer these workplace safety measures related to workplace violence. And it adds penalties which could be assessed to local governments for violations of these provisions. You have a reprint in front of you. It's a very thick bill because a lot of the changes in the bill relate to just changing words like public body, government to public body. And also the sponsor has offered an amendment, or a series of amendments designed to address the concerns of the Maryland Department of Labor as well as MACO and MML. So very, very quickly, the bill established an assistant commissioner for public employee health and safety, and that is removed at the request, I believe, of MDL, because they have the authority to do a lot of this on their own, and the commissioner can take all these duties. And again, there's a lot of changes in here that relate to unnecessary language, and a lot of language that relates to removing the assistant commissioner. If you go to page 3 of 17, field work location, this was viewed unnecessary, and I think it also was a request by either MML or MACO that come out. There's a definition that was added in the bill originally on page 4 that deals with places of, expands on what place of employment means, but the place of employment is pretty general anyway, so that was not necessary, and it also related to field work location. And the middle part of page 4, you're seeing that the crux of what you're getting at is, these measures are to address workplace violence and make it a matter of worker safety in the state for public employees. There's intent language on page 5. If you go to page 6, there's another amendment offered by the sponsor that I think addresses either the concerns of MACO or MML, where residents of those served by public bodies are safe and healthy. These are the duties that would address workplace violence for the unit. If you go to page 7, there's another amendment that all this stuff comes out because you, through the next page, this is all removed because it has to deal with the assistant commissioner, which is no longer part of the bill. And the duties would be transferred instead to the Commissioner of Labor and Industry. On page 8, you see the establishment of the unit on workplace safety, or on the unit on public employee safety and health. And on page 9, the sponsors offered amendments striking additional requirements to the unit because a lot of this is covered under existing law for the commissioner. And then on the bottom, there's written report by the commissioner relating to workplace safety as it relates to workplace violence for public employees or public entities. There's, on the bottom of page 10, there's new language that specifies the notice requirements provided by the Attorney General. The next pages are all struck again because these are expanded safety inspection requirements that are already fall under the purview of the MOSH program. On page 12, there's language that relating that if there's certain search warrants requested by MOSH, they would be given a priority if they relate to workplace violence from the Attorney General to implement. And there's, on page 13, this begins the citation and penalty provisions that would apply to public bodies for violations of the law, and that goes to the bottom of the page. And let's see, if we go to page 15, there's an amendment that requires each public body to commission certain reporting requirements. Again, the MACO and MML thought they didn't, this was their request to cut down some of these reporting requirements. At the bottom of the page, there's penalties.
Because it was quarterly, so what is it now? It agreed.
It will require by regulation.
I'm sorry, what the existing reporting period is?
The existing, well, you have a new reporting period that would, a commissioner shall require by regulation that each public body keep accurate record of information described. And then you just.
So the quarterly reporting on
whatever
had come out.
Yeah, whatever the reporting requirement under existing law would apply to these public bodies.
Okay.
And on the bottom, these are penalties for public officials who violate the provisions of workplace safety as it relates to violence. And then on page 16, there's if there's failure to pay penalties within certain days, certain actions have to be taken. And on the last page, all the penalties, all these civil penalties will go to this Maryland Apprenticeship and Training Program. And at the bottom, there are provisions that the board, the Maryland Occupational Safety and Health Board would have to adopt, and it specifies what they would have to adopt relating to workplace violence standards by the board. And I believe the senator can relay that I think MACO and MML have reviewed these amendments and they are fine with them.
My understanding is that we were all simpatico.
Second. Senator Jackson seconded. Senator Knapp, you have a question?
You just real quick, that was a lot of information. MML is opposed to this, and MACO had an opposition with amendment, not to the concept, but just to the language. Specifically MML, how was their issue resolved?
All those amendments.
The sponsor, I believe, you know, he can speak to how he worked with the opposition.
Oh, but I think I know. Thank you. That's that. I don't want to belabor it.
So
It's
what
fine.
do you want to do?
I think I'll vote no, and then
Do you
can.
want to hold the bill and talk to MML?
Yes.
Okay.
Yes, please. Yep.
Actually wanting to vote for it, I just want to be sure we're on
Okay.
track. Yep.
So now we have Senate Bill 474, Health Insurance Adverse Decisions, Reporting and Exams. I'm going to ask to hold it for an amendment that came up today, and David's working on the amendment. So 474 is a hold, yes.
Can I just quickly, in reference to that last bill, if MML or MACO at this point have any problem with it,
As far as I'm concerned, I'm just going to push the bill as it is and ask the committee to vote it because I'm going to be done with them on this. Okay.
It did cost somebody their life, which I think is important for us to remember.
Yeah.
Senate Bill 547, Commission to Study Health Insurance Pooling.
Okay, this bill would establish a commission to study health insurance pooling to study the pooling of public health insurance purchasing between the state, counties, municipalities, and other public bodies, and including county boards of education. The purpose here is to maximize the value and efficiency while maintaining a broad package of benefits. There's a reprint in front of you because the treasurer asked to be left off the commission, so the amendments strike the treasurer from the commission. DBM is going to be responsible, or the secretary is going to be responsible for running the commission, and in their letter of information said they have the resources to able to staff the commission.
Move favorable. Second.
Just a quick question, Madam Chair. I just have a quick question, Madam Chair.
Yes.
I really don't understand. But why would it requires one member from the Senate, but it has to be from B&T?
Because generally speaking, the B&T deals with the state health plan regarding legislation and matters related to that. There was legislation in before like 2018 or 2019 that authorized pooling.
The sponsor's not also on B&T, so
Yeah.
I guess somebody,
She's not on B&T.
no.
And I spoke with the chair of B&T, and since
Unless
they,
you want to do it, it's not going to be financed.
No, I don't want to do it. And I just, but we're also making another committee do something.
I spoke with the chair, and he said it was fine for somebody to B&T to serve on this group.
I didn't say you would. I thought David might have.
No problem, just one question. May I, this is a bit odd request, but could I be added as a co-sponsor?
Yeah.
I really like this idea.
This is a Moorheim idea.
They all want co-sponsors.
Who doesn't want to be a co-sponsor?
Okay,
No,
you're gonna go with the group?
I'll go, just to make it easier for
So
Tammy.
all in favor of Senate Bill 547 as amended?
No.
All right.
Wait, I wasn't sure, clear. Senator Washington, do you want to be on the? Yeah, sure. Okay, all right.
It was a unanimous vote. Okay.
Madam Chair, I move to withdraw Bill 895 and Senate Bill 41.
No, we got to do it right.
No, we got another one?
We have to move a motion, we have to have a motion unfavorable withdrawn for Senate Bill 895, 481, and 934. Not on your list, 934 is the Maryland Premium Cigar Bill.
Nice.
Okay, we have Senator Washington and Senator Reedy, all in favor of the withdrawal. All in favor of the unfavorable withdrawal. Okay, unanimous.
Just for the record, there was a vote change on Senate Bill 674. The three of us, we're going to vote no.
Tammy, did you get that? Thank you.
Thank you.
No.
They already voted no on that one. Madam Chair, do you want me to end this?
Yes.